Welcome back to the Southern Scene on WSAV. It's time now for our legal scene. You know, we all deal with banks, whether we like to or not. We cash our checks, we make deposits, we even pay our bills through the banking industry. And over the years, well, we take out loans and we pay them back. But what happens when it appears the bank controls way too much? Can a lender be held liable for a borrower's financial losses that are directly or indirectly related to the bank's actions? Well, the answer may surprise you. And that's what we're talking about on the legal scene today, lender liability. And now our legal expert, Mark Tate, joins us on the legal scene. So Mark, let's talk about lender liability.
Okay.
What exactly is lender liability?
You know, it's an interesting question because, people think right now that banks are their friends. And while we all have people who are bankers who are friends, the big institutional banks are not in a position right now where they are fostering positive small business growth. And anyone who owns a small business knows well that the banking industry has changed dramatically recently. And while they continue with their practices like charging the people least able to afford check fees, they're charging them bounce check fees. The people least able to afford high interest loans, they're charging them high interest loans. And it's not necessarily always related to risk. But what happens is banks extend loans, and then sometimes they get real anxious about where their money's going to come from to pay them back. And so what you see is hyperactive bankers, and there are many that we have seen, and they become very involved in the businesses that they've extended credit to, and they begin making demands. We need to see monthly profit and loss statements. We need to approve every expenditure that you undertake with our line of credit, which we've extended you. We need to review and account for all of your accounts receivable.
So it's like the bank is taking more control than they actually...
Right. That's right. They're taking over. And what they generally do, and where lender liability really comes into play, is you'll see a banker begin to ask for these kinds of things, and it's usually because the regulators are breathing down their necks, and they have what they think is a bad loan or an underperforming loan or a rated loan. And so they begin to get into the business and they take over how that business is run. And then they get the business caught out essentially on a ledge, and they have the bank has them extended fully on their credit, and they're telling them how to run the business, and the business isn't being run by people who know how to run it. So what we have is a situation where the banks extend credit and they run the businesses into the ground, and when the business needs more capital to keep running and make a profit, the banks cut them off. When that happens, the victim, while broke and struggling to pay its employees and pay its rent and payroll, they do have a cause of action, and there is a cause of action for exactly what these types of banks do.
But there is a process that banks have to follow. I mean, they can't just take controlling interest or foreclose on a home or anything like that.
No. Well, I mean, Bank of America is famous for its wrongful foreclosures. Suntrust is famous for foreclosing on people who own their buildings outright. They're famous for claiming loans are what they call cross-collateralized, and going and taking one piece of property to pay off a loan that is collateralized by another. These things happen, and you have a cause of action against them. We have a marvelous thing here, and the United States Constitution says that the right to trial by jury in civil cases shall be preserved. And so just like people talk about the First Amendment and the Second Amendment, we have a constitutional guarantee that we can get a trial by a jury in a civil case. When you have these things happen to you, when a small business is taken over by a lender, when they run it into the ground, when they leave you on the lurch with inadequate credit to run your company because of the way they've told you you have to comply, you can sue them.
So what's your best advice for borrowers?
Yeah, well, it's difficult. I think that, businesses, first of all, need to really examine what they're getting themselves into when they start borrowing money. So small businesses need a professional, smart money manager to know how to deal with banks.
If somebody's watching and they think that they may have a lender liability case, what would you say to them?
Well, I think the first thing that somebody, a small business or a medium-sized business, needs to find out is, there's a reason why you fail. And either you have a flawed business plan or you have a flawed product or a flawed service, something that's not hooking. And, that's the first test. If that's the reason that your business has failed, there's nothing anybody can do to help you. But if you have a strong business that has strong sales and you have a credit problem where, you were waiting on your accounts receivable for 30 days and your bank swept your accounts because you got extended, I would want to talk to you. I want to talk to you because I think you may in fact have a cause of action against them. And, strong businesses can have problems. And, General Motors had a cash flow problem and they had a line of credit the day after they filed bankruptcy. And so
Tate Law Group handles cases like this.
we do, absolutely.
Okay, well, we want to thank you, Mark, for joining us.
I want to thank you for letting me.
If you'd like more information on Mark Tate and Tate Law Group, all you have to do is go to the website you see right on your screen. You can also send us a message if you'd like a legal question answered. Just find us on Facebook, The Southern Scene, or you can always go to our website, wsav.com. We'll make sure we get all your legal questions answered for you.